Good morning, ladies and gentlemen. We see we are very early in the morning, but I see already many people attending our session. My name is Cosimo Monda. I'm the director of the European Center on Privacy and Cybersecurity at Maastricht University. I will be the chairman of this session, but since we have many distinguished panelists, probably I will not say too much about. I will leave the moderator, Professor Paolo Balboni, from the University of Maastricht, professor on privacy and cybersecurity, but also ICT lawyer, who will be the moderator of this session. I will give it 8 minutes per speakers in order to leave time for questions. The panelists here on my left, we start with Albena. Albena from the, I don't know the name, it's very difficult for me to pronounce, I don't want to make a mistake, but Albena, she will say her last name, from Research Innovation on the Commission. Then we have Marty Abrams from International Accountability, Institute of Accountability Foundation in Texas, from the States. Then we have Professor Michel Dumontier, data scientist at Maastricht University. And then we have Aurélie Pauls, who is a data governance and privacy engineer, also member of the ethical board of the European Data Protection Supervisor. And finally, Giovanni Comande from the Scuola Superiore Sant'Anna, also professor there. I leave immediately the floor to Paolo to introduce a little bit the topic, and then we can start the session. Thank you.
Thank you very much, Cosimo. Welcome, everybody. Good morning. Good morning also to the speakers, and thank you very much for joining us. I think it's a pretty stellar panel that we have here. It's fairly mixture in terms of background and also angles that they're going to take on the topic. So 3 pillars for this topic. Ethics is research is the subject matter, and all the questions related to what is research data, but also how to perform research in compliance with the GDPR and other applicable privacy legislation, which is pretty much still an open question that poses quite some issues. Ethics, so not just complying with the law, but also try to be ethical in processing personal data. We all know that since a couple of years, this has been a very, very important focus of the European Data Protection Supervisor and also of supervisory authorities in general. And last but not least, how to try to enforce compliance and ethics also into algorithms, for example, developing the concept of fairness by design, which is a stream of research that we are conducting at Maastricht University. Without any further ado, I will leave the floor to the first speaker. Albena, the floor is yours.
Good morning, thank you very much. The topic is ethics and research, and this is what we do in DG Research and Innovation in Ethics and Research Integrity sector. We're living in smart cities, we are driving smart cars, we are living in smart homes, we can edit our genes. AI has enabled us to detect 95% of skin cancer, but also have enabled us to create the killer robots. AI and new technologies have bring a lot of new innovations, and they are helping us to live better, to live healthier, and to live in a more enjoyable way. At the same time, people are less and less willing to share their data. And then the question is why? Why people are not trusting the technologies, and why people are less and less trusting the research? The latest Eurobarometer survey in 2016 showed that only 21% of the European citizens are willing to give their data, anonymized data, for research purposes to public institutions and research bodies. At the same time, the new technologies, Internet of Things, makes it more and more difficult to actually protect our data, to be owners of our data, and to be in control of our data. So how shall we encourage research, at the same time protect the basic human rights of the individuals? And what is more important, to advance in the research or to protect the basic and individual human rights? The answer to some...
The green.
Okay. The answer to some companies and researchers was, let's move fast and break things. If we are not moving fast enough, if we are not breaking things, we are not moving fast enough. Can we actually afford this? Can we afford to lower our human rights standards, to change our ethical standards in order to advance, and is it worth it? The answer to of the European Union was the adoption of GDPR, and the regulation was welcomed with mixed reactions from the research community. On one hand, we had researchers who were saying, great, that's great, we can do everything with data because we have all these wonderful research derogations. And there were others who were saying, wow, 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 this will really prevent us to do a great breaking research because we can't process data further, we need informed consent, and etc. What is good for the research, of course, are all the research derogations. What is not that good is that we don't have a precise definition of what is research. And the definition is very broad, which can enable different actors to use the research derogations for different purposes. GDPR gives us 6 legal grounds to process data, and informed consent is only one of them. Then this immediately opened the debate how to reconcile the need for informing our research participants that they are actually part of a research project, and then process data based on legitimate or public interest. Can we do this? GDPR says we have to process data in a lawful manner, but it also says we have to process it in a fair manner. In order to safeguard the human rights of all the research participants in H2020 project, we have established ethics review process that looks at data processing from an ethics perspective, because law, as we heard the European Data Protection Supervisor saying, comes before, during, and after the law. And it helps us interpret the law. Horizon 2020 projects that are based not only on the compliance with the legal framework, because not everything that is legal is always ethical, but it's also based on the compliance with the ethics standards established. In order to make sure that all the research participants are well safeguarded in terms of data processing, the Commission encourages informed consent, wherever possible, to be applied as a legal basis for data processing for research purposes. Whenever this is not possible, and we do realize that it's not always possible, the researcher and the data controller have to explain, is it fair the way they process data of their research participants? Is it fair for the research participants not to know what has been done with their data and that they are actually part of the research? Another important milestone in our ethics review process is the assessment of the ethics risks related to the data processing. And there we go beyond GDPR because we are looking not only at the ethics risks for the particular individuals that are affected by the research, but also risks for third party, their family members, or risks of the entire groups of population. Sometimes research with huge anonymous data sets can actually lead to stigmatization and discrimination of huge amounts of population. And now we are moving towards ethics by design. In December last year, the Commission adopted its integrated plan on artificial intelligence, where the Commission committed itself to integrate ethics by design for all calls for artificial intelligence that we are going to fund. The question, of course, is what is ethics by design? And as an overreaching concept, it will embed the fairness by design, the privacy by design, data protection by design, and many other aspects. What is extremely important, however, is that all these principles that we are discussing are not just delivered to the research community, but we have the research community intake and input on how exactly ethics and fairness should be applied in the research context. And then design is the second important word in this phrase, because we should not think of embedding data protection, fairness, and ethics after we have constructed our research methodology, but we should think on how to embed it in the very early stage of conceptions. And this is not always happening. And also we have to think on how to make sure that it's not only the fairness of data processing in research context, it's not only the ethics of the research, but how this will be further transferred to the new products developed by the research community, because that's crucial. The effects, the anticipated effects of technology are getting bigger and bigger, and one of our funded projects, Siena, looking at the social impacts of AI and robotics. For example, they predicted that while the two technologies will help us live better and live longer, especially in the healthcare sector, they can also negatively affect especially the vulnerable population, elderly people, and this can lead to loss of autonomy and loss of privacy, among other issues. So the topic of today, ethics by design, fairness by design, is of extreme importance, and I'm looking forward to other fellow speakers to hear how we can actually embed fairness by design in our projects. Thank you very much.
Thank you very much, Albena. Giovanni, the floor is yours.
May I have the... It's the green, you say? Yeah, okay. Good morning, everybody, and don't look at me, Albena. I will not be giving answers, maybe asking some question. The main idea that I would like to put forward in these few minutes is that in research, there has been, in later years, a deep transformative change, which is mainly related to data-intensive research, which is having a sort of a transformative effect also on the methodology to do research. Because before we were moving from specific data sets, in healthcare would be just one clear example in a few moments, selecting data which were clearly related to the specific field. Now with analytics, with big data, the nature of the data we are looking to find a research outcome has been completely changed. So data that ideally and originally were not related to the topic we would be investigating became suddenly of huge relevance. We were moving from hypotheticals and trying to find an answer, a solution. Now we are looking for the questions in the data themselves. And this is a deep methodological change in every area of science. Now, what does it require is that there might be possible to do much more further processing of data, so more reuse of data. Certainly we'll need some large scale, and as you realize, I'm just introducing some buzzy and fuzzy words from the GDPR, which actually match for what science is asking. More linking between data sets. And all this is clearly creating tensions. So if we look to the example of healthcare, as I was anticipating, there are a number of challenges which, again, are creating troubles in doing research, and leave it aside the GDPR. So if we want to somehow protect, in the traditional paradigm, we were using either consent, as Albena was suggesting, or anonymization. That was the model of the alternatives. But both of them somehow give away a lot of richness. The more you anonymize, the less you can reach results. The more you give to individuals their control, the less you can have, once again, results, because they can somehow bias and manipulate. On the other hand, there is another issue. We're talking about ethics, so the social benefits, the go fast and break things model of Albena, and there is another layer of trade-off that has to be done between the protection of fundamental rights and trying to harness the social benefits of research. So where it is leading us, we have a number of principles, but what matters more, and this is the only slides that might matter to us, the fact that we have data-intensive research in any field that is bringing together data, again, that technically we're not actually the data set on which, I don't know, a biologist or a social scientist would have been working with 5 years ago, or even less, right? This is creating a sort of magical tension. I could not read from here. So from the upper corner, from the top to the right, you have some principles that are embedded in the GDPR. And on the left column, you have some of the tendency, if you want, that are related to data-intensive research. And in the middle, when you cross them, you realize where are the higher levels of tensions among the systems. So I cannot read. So if you begin to look at it, and for instance, think about the legal basis, there is a huge tension. Albena was suggesting we should use more consent for research, but to a larger extent, consent might not be the answer. 2 examples. First example, consent must be specific, free, informed, whatever it will be, but it should be specific. Now, how specific would it be without giving away the possibility of reuse, of linking? So one other avenue could be legitimate interest. But the legitimate interest, it's not possible to use it, doesn't exist as a legal basis for sensitive data, for the particular data. And for what I said at the beginning, clearly enough, even if I'm not working on health data, for instance, I will end up to have, for instance, health-inflected information that will be there. So whenever you touch one principle trying to find a solution, you create another tension. This doesn't mean that we cannot do it, but I'm just trying to suggest that we have to cope with all these tensions, trying to do a lot of micro and macro balancing between competing interests. On the one hand, protection of individual rights. On the other hand, social welfare, for instance, the public benefit of doing research. And all this is in this domain of data-intensive research, which is really transforming all corners of what we are doing. Tensions over tension. The second example I was mentioning, it was the consent, how wide open it could be. And then if we look to the solutions, the possible solution that we have, we realize that the GDPR, it's opening the way to have research-specific consent possibilities. Meaning, since as an individual I have a right to consent to specific kind of research, a specific use of my data. So for instance, I want to give my genetic information only for public purpose research, but not for profit companies. Just one example. So the member states in the European Union could begin to frame the possibility of giving specific wide research consent, so specific area. What would this entail and produce as a result is that we can have a sort of modular consent in which we can expand the possibility of giving broad choices, because the broad choice would allow more easier reuse of data, more easy linkage of data. Otherwise, we'll be just loosening our ends, all right? Those are tensions. Solutions are included in the tensions, but it will have to be managed one by one. Thank you.
Thank you very much, Giovanni. Martin, it's your turn. Thank you.
Well, thank you. I'm not sure that's where my slides start.
I will give you.
Okay. That's all right. I can talk without my slides.
Start talking.
There were some of my slides, but it wasn't the first slide. That's all right. My name is Marty Abrams, and I'm probably the least qualified person here to be on this panel, but I'm on the panel anyway. I'm a policy theorist. I've been doing information policy theory for about 30 years, and the last 10 have been really trying to figure out how we can ethically operate in a world of big data and now increasingly artificial intelligence. And I've mostly done that in terms of the private sector's use of data, and now the question is, how do you begin to apply against the fact that we're in a research environment where researchers are trying to use the data? We also truly understand that the concept of consent today is about people truly understanding what is going to be done with the data when we're permissioning the data based on consent. And increasingly, I think that much of what we do with data is beyond the common understanding of myself and, in many cases, most people. So the question is, how do you begin to cascade down through a matrix before you get to this question of what does it mean to do fair processing? And after doing privacy for 30 years, there are three essential components of privacy, and all three of those are important and need to be applied where they're appropriate to apply, sometimes more than one. So the first component of privacy that needs to be applied is the concept of seclusion. Part of privacy is this ability to be in an environment where you're free of observation, where you're free of being viewed, and increasingly in an observational world that is more limited. Most of the research that we're talking about here today is not research where you start with an observation of the individual directly. Most of the time we're talking about data that has already been observed. So the question of seclusion is not really the right question in terms of how do we get to the question, the answer that it's appropriate to use data. The second is autonomy, and this is where consent comes into play. And autonomy is essentially that I should have the right to have a space, have a definition of myself that is a definition that I've framed, and not just a definition that's framed by the digital history I leave behind. And there are many settings in which the whole question of when we should actually think about where consent comes into play. If we're doing traditional clinical research, 70 years of history tells us that absolutely consent is in play because we're touching and feeling and in contact with individuals. So indeed, the whole question is, how do we think about the fact that it's not really about autonomy? And the third major component of privacy or data protection is the concept of fair processing. And fair processing is where all of the complexity comes in today. The IAF, the organization I lead, has worked with the Canadian Data Protection Authority, has worked with the Hong Kong Data Protection Authority to begin to think about how you parse fairness in a world that increasingly is about using data. The key concept that you start with is that the generation of insights is less impactful on individuals than the actual application of insights. Now, it's not totally unimpactful. If I'm a chemist and I'm doing research to create the best elements for mass destruction of people, that's obviously the research is negatively impactful, and hopefully our friends at the Commission won't fund that research, but it is research that is indeed some research that's been done in the past. But typically when we're talking about this whole concept of when do we apply, when we actually create risk, it's really when it goes to the implementation of the insights themselves. But the fact is that the insight development needs to be within an ethical frame. The fact is that ethics are different from country to country, region to region, profession to profession. I can't sit here and tell you what the appropriate ethics are. I also can tell you that once ethics become a societal norm that's captured by law, they're no longer ethics. They're the law, and you have to comply with the law. And someone challenged me earlier this week, ethics isn't an excuse not to comply with the law, and I would absolutely agree with that. The fact is, though, that all laws leave gray area in which organizations and people operate. So the fact is that professions and organizations need to have a frame for capturing the key issues when you're making a decision on whether processing is fair. And in all of our work, the concept that we've captured as part of that is clearest is that if you're doing a determination of what is fair, you need to start off with the stakeholder analysis. And a stakeholder analysis means who are the stakeholders who are going to be impacted by whatever it is that I'm doing with information. And the stakeholder is not just you as a researcher or not just me as an individual who the data may pertain to. The fact is those stakeholders can be very broad. In the case of research related to collision avoidance systems in cars, the stakeholders don't just include me as the driver who's being observed. It includes all those people I might not hit because the anti-collision braking is actually working. In the case of things like the provision of consumer credit, while research there can lead to some people being denied credit, in some third world countries, it actually provides for the creation of a consumer economy. So you have to actually be able to do that stakeholder analysis. But that stakeholder analysis can't be done in a vacuum. It changes the way we think about transparency. So the fact is that transparency used to be, this is the data that I'm going to use. Here's a very complicated explanation of what I'm going to do with that data. At least for the private sector, in a world where we're using data increasingly beyond common understanding, part of that concept of transparency is a translation of my values so you can understand the values that are being used to make the determination of what is appropriate and fair for each of the stakeholders involved. And that also has to be within a process that really has connection points. So increasingly for private sector companies, we say that the data scientist develops the project by values by design or ethics by design, and they're based on the organizational ethics that have cascaded down. But then that work needs to be reviewed by someone else who has similar skills but is independent of the specific project, and that there need to be audit points that are collected that allow for an outside party to see a demonstration that what was done was both legal, fair, and just. And that then leads us to the concept of data stewardship, which is beyond my 10 minutes, and that will be saved for next year's conference.
Thank you very much, Martin. Aurélie, please, the floor is yours.
Okay, thank you very much. I was a bit surprised yesterday. There was a panel by the Ohio University as well about fairness. And I was a bit surprised by the link between fairness and ethics. Because having sat on the ethics advisory group of the EDPS, we talked a lot about values, obviously, and it's part of the document that Albena mentioned as well. But when I think of fairness, I usually think of my son. He's 10 years old, and when I decide something between my son and my daughter, he typically looks at me and he goes, "No es justo." It's not fair. And, well, in order to fix those things between my little scale population of two 10 years olds, I have to balance things. And often I have to balance things within context and in sequence. And so, what we know is that when it comes to big data, discrimination is already part, typically, of the databases. What really surprises me often when we do big data projects is that we don't go through, basic data descriptions, or what I learned at university in terms of statistics, to have an idea of what your population actually looks like. What I see often is that, we go through big data projects, we come out with correlations and causations, and this kind of worries me because, actions are being taken based on maybe not enough understanding to see whether our population are representative or not. But on the other hand, it's not always easy. So working in digital, I had these questions. I flocked to digital because there was a lot of data there with my economics background, and asked those questions to say, the decisions or the correlations that I found, does it actually make sense? How can I prove, how can I use the hypothesis of statistics to make sure that this is actually something that's robust enough to move forward? And that's not actually always easy. The next question that then came along was more about, does it actually matter? Should I really care about the fact whether my population is representative? Should I go through these types of exercises if I'm trying to define whether somebody prefers a strawberry yogurt to a banana yogurt? When it comes to marketing activities, probably not. But when it comes to other types of decisions that might affect people's lives, it's very much possible that we need to be more robust about the consequences of the data or the recommendations that come out of the research. So this brings me back to this idea of, it actually depends on outcomes. Is fairness important? Well, it might be. It depends actually on the outcomes of the data itself. And which then brings me back to another concept within data protection law, which is often brushed over because we talk about the legal basis for processing, consent, or legitimate interest, and these balances. Personally, I prefer consent from a technical perspective, but we don't always talk about purpose. So it's kind of a given all the time. It's like, obviously, we define the purpose. But in reality, what I see, at least from a technical perspective, is purpose can be very broadly defined in very poetic ways by certain lawyers. And when you're trying to pass data between different systems, your purpose is sometimes difficult to define. You have data scientists that ask, am I actually using the same purpose? Does that work, yes or no? And this is something where I'd like to see a lot more research on. How can we structure, how can we classify purpose? I'm not saying it's easy, but I think this is something that should clearly be focused on a bit more and not just brush over this idea that, it's clearly defined. What I would see in terms of fairness by design, but I think Michel will talk a bit more about this as well, is certainly when we're talking about pre-project mechanisms, the idea of, let's define these lawful bases, let's see what we're going to use, and which is where legitimate interest is an interesting exercise in fairness, because you have to start balancing these rights, which is, not easy either. Think about this idea of representativity. Should we care that when we do research, for example, about certain medical conditions. There is more bias related to men or women. Do gender actually matter within the type of research that we do, or other types of variables? And then, obviously, what comes after the project as well is this idea that, well, we actually need feedback loops based on transparency, so that people can actually understand, well, how the data has been computed, and make sure that if they think there is unfairness somewhere, they can input that within the research, which often doesn't really exist. So in order to conclude, what I would say is that I think there's, generally speaking, a lot of work to be done when it comes to fairness by design, but that I see this on an individual level. It's about the individual per se. I think that ethics by design is more about social maximization, and that there's kind of this tension between the two, between this individual fairness, does this make sense? And we still have a lot of work to be done in order to get to making sure that everybody has a voice within the way data is being used, but also this more broader vision of social benefits and how we maximize this through ethics by design. So just a couple of thoughts. Thank you.
Thank you very much, Aurelie. Michel, it's your turn, please.
Thank you. So really thoughtful comments in the past few panelists, and it's really quite inspiring to be here. I'm a biomedical researcher. I'm a data scientist at Maastricht University, and I will play a bit on the word fairness, because for us, we have been working on a concept called FAIR in the context of making particularly research content findable, accessible, interoperable, and reusable. And we have laid out a set of principles to help guide research work so that content is more easy to find and more easy to reuse. And I think here, in the context of this panel, is what makes it also ethical. This is really an international bottom-up paradigm, I think, for the discovery and reuse of digital content by and for people and machines. And I think this is a bit the difference. I foresee that while we are doing a lot of this for people, we imagine that machines will have a very important part in data processing and also in coming up with new functions and business. Importantly here too is that the idea of FAIR has been endorsed by the European Commission and also through the G20. It is a key facet in the European Open Science Cloud, and Horizon 2020, and many other funding mechanisms around the world. So what is it? Just briefly, I know that I'm speaking probably to a less technical audience. So primarily we're interested in research data management, digital object management. So we look at components relating to identifiers for data sets, as well as individual data items within those data sets and the relations that hold between them. High quality metadata, the use of community standards, the use of community vocabularies, expansive provenance to understand where this content came from and how it was generated, commitments to make this content available in the longest term possible, and also clarity in the terms of use of these data. And this is needed because as a biomedical researcher, we, myself, and I think increasingly many others, when I give talks at universities, most of the people in the audiences that I speak to are using other people's data. They don't collect their own data, they use other people's data. And there's so much data available, and this is a very good place to start the conversation. However, despite the wide availability of data, we spend most of our time trying to find it, trying to make sense of it, trying to understand what our rights are and what our responsibilities are with respect to these data, how we can use them for the new purpose that we intend, and also how to create value and disseminate this value to society. So a good example, I think, is in the field of medicine. And the idea in medicine and the state of the art is to combine data from lots of different modalities, not only from the data that the physician collects and the hospital systems collects, but also information about your environment, information about your own individual self, so the quantified self, your activity through your Fitbit, for instance, what you eat, perhaps even what you are feeling and what you express in social media. All of these are informative about the state of your health and of your well-being. And the idea in precision medicine is to take these data and to help understand both the basis for illness and also to posit new mechanisms for treating illness and to successfully execute on treatment plans. However, working with digital data, especially health data, is really quite challenging. And I think, again, first and foremost, as a biomedical researcher, we ask what data exists. We know lots of data exists, but where is it and how can I gain access to it in a legal way? And this is really quite difficult, not only because we have restrictions within every single institution, but that these rules change across the legal jurisdictions. The second question, I think, is also, do we have consent from the data subjects in order to process their data with the intent that we have? This was raised previously. And then, more importantly, is if I intend to, or in order to obtain the insight I'm looking for, I need to combine data from different sources that were perhaps obtained through different consents. How do I mitigate that? Are there particular data elements that are protected? So for us, I'm just moved to the Netherlands 2 years ago, and we learned that we cannot use the citizen identifier called the BSN in our data processing. And so when we have data from multiple different jurisdictions, while there is consent, we have no mechanism to join these data and to learn the associations. And secondly, when data are missing, how do we impute these missing data? And should we be able to? These are assumptions that we might make about the individuals that are not reflected in actual data, but they are important in data processing. And then finally, how do we learn from these data? We are intending to learn patterns as the point of research. And how do we do this without revealing secrets about the individuals? How do we do data processing en masse? And then finally, this was also raised, which is that if some of our population elects not to make their data available to our research, it means that we will introduce a particular bias in our data processing. And so if we build AI applications to, for instance, in the context of healthcare, and we have no representative sample that we should have learned from in order to provide care to individuals, then we are at a disadvantage for them, and I think as well as for us. And so I think this opens the question about, do we need to have provisions so that we can address bias in the broadest possible manner, and perhaps at the expense of individual rights? So in some sense, I think the GDPR was an interesting first advance to bring the data agenda, I think, to the forefront of the public policy discussion. However, I think we need to go further. We need to form a new social contract that are supported both by legal and technological infrastructures that facilitate the discovery and reuse of digital resources such as personal health data for people and for machines. In our project, one of our projects that we have is funded through the Dutch National Research Agenda. It is called Fair Health. It's about analyzing fair health data in a responsible manner. Here, the challenge is that we want to learn social and economic determinants of health, in a particular type 2 diabetes. These data are located in different jurisdictions. One is with Statistics Netherlands, and the other is in the medical center at Maastricht University. Again, I sort of outlined that we have this problem about data linking, in particular between these organizations. One is a government organization. They have the ability to use the citizen identifier to do data joins and to do data analysis, but we do not. So we are trying to figure out how can we combine these data to learn this association exists between two physically separated data sets. This poses a challenge not only technically from the idea of how do we learn or use machine learning in this distributed fashion, but also how do we maintain the privacy of the individuals from which we would learn the data. We have no intent to include in our model such detail that would allow us to re-identify individuals, and how do we show that that can be the case. And secondly, we also have this issue of governance. The way that people deal with sensitive data are vastly different. The way that the Maastricht study and the Maastricht University Medical Center deal with data For instance, I can obtain a physical copy of this data on a USB key, and that is not the case at CBS. Now, why is that? I think this lack of harmony or harmonization between data processing methods is also harmful for us and creates a security flaw. So finally, what I think we are proposing is fairness by design, both from the start, from the moment that you collect those data, you have to consider that they will be used by others. And so we have to create a vehicle and a mechanism by which we allow this to happen, and I think that in a way that is ethical and legal, and is facilitated dramatically past the way that we're doing now. What we're doing now is we have checkboxes at the end of the projects, and we need to do it by design, and this is the idea. So for instance, what if data were never downloadable? What if you could not obtain a copy of the data? However, the data processing algorithms that you wanted to use would be vetted by the community and would be allowed to operate, for instance, through the use of smart contracts. This could be one mechanism by which we can ensure that there is transparency about what processing is occurring, and also an opportunity to capture an audit trail of all processing that occurred from the collection of the data through down to the benefit that you intend to apply in society. Fine-grained access control to ensure that individuals can restrict which data elements they want to make available, or again, what projects should make them available to wider communities. And finally, I think just this idea that we can do this work efficiently and transparently and in a privacy-preserving manner. Thank you.
Thank you very much, Michel. Thank you very much for all of you. I have to say, the more you have been speaking about this topic, and the more I realize how difficult is now my task to put everything together, because there is so much food for thought and so much that has been said on different domains. I'll try to add a few reflections, and then of course I will leave the floor open for questions. I'd like to start from the presentation of Giovanni. Giovanni, you said something I think is interesting, in the sense that there has been a huge shift in dealing with data and research. So before, researchers were looking at data for answers, and now they're looking at data to realize the right questions to pose themselves, because you have such a vast amount of data available and such possible correlations that when you start a research project, you just know maybe 10% of what you're gonna effectively discover after you evolve with that project. And I think this is very important, because this challenges from the very outset the old principle of privacy and data protection. And it was also mentioned by the other speakers, because if we don't know exactly what is going to be our path during the research, how can we be transparent? How can we be specific with respect to purposes? How can we even rely on lawful basis like legitimate interest, where per se you need to balance what is going to be the risk for the individual, but then you don't know exactly up front what is the potential risk of the individual. Therefore, this balancing test may not be accurate. And one point after that is that this concept of looking at data for questions is about then using personal data for possible different purposes, and then the whole compatibility test, which is also a balancing test based on the risk for the individual. So I think, just by way of this brief introduction, we are confirming something that everybody, like all of us in the room dealing with personal data, I think has already realized. 1 year almost after the 25th of May 2018, we are realizing that we are witnessing a massive change in the whole ecosystem related to privacy and data protection. It was not just a legislative change, is a social change, is economical change, is a research change, and so on and so forth. And in order to carry out that change, it does not take one night from the 24th of May to the 25th of May 2018. But it takes years, probably. So we are witnessing a process now that is going to take years before the research domain can fully comply with the GDPR and being reassured that what the researchers are doing is in compliance with that regulation, which creates uncertainty, and it creates an urgency to act from the European institution, from the supervisory authority, from the stakeholders, for the whole ecosystem. So first and foremost, this is a big call to action, to participate in shaping the future of research in a way that is in compliance with the law and also sustainable, of course. And then I come to the concept of ethics and fairness. I like the fact that, Aurélie, you said, hey, look, fairness and ethics may not be the same. Fairness and ethics may not be something that you should deal exactly together. Ethics is more about a social maximization of effects, and fairness is more individual. And therefore, we need to keep that into consideration when we are acting on fairness or acting on ethics. And I think this should also, it's very interesting, it should also be taken into consideration in the ethical guidelines of the European Commission. There is another point here, which is the fact that you, Martin, mentioned that if you make ethics in the law, this is not ethics anymore, it's law. And it loses maybe some flexibility that you need to the concept of ethics. And it is not ethics, that's the point. It's becoming a provision that can be sanctioned and acted upon. And the question is, are we looking at ethics in a way to embed it in legal provisions, or do we want to keep it outside the legal domain? That's, I think, a very fundamental question that we really need to address. Then on the last point, Michel, I think you explained very well this tension of what are we doing now that we're doing research and we are looking for data and we want to process the personal data in the right way, we want to maximize the benefit, we don't want to step over the data subject rights, but we don't have answers to that question. And I think this is very, very significant what we're talking about. We're talking about research in the medical field, maybe projected, of course, with all the best intention, but there are no answers to the question, what can I do and what I can't do in order to be sure that I'm not breaking the law. That is a very, very big issue that I think it was underestimated in the legislative process in Europe. And you also touch upon another very important thing. We are talking about Europe, but we should talk about at the global level, because this is a global problem and it should be addressed possibly in a global way. If not, we're making a second mistake. Try to define borders when we regulate research, which is absolutely absurd, actually. And you also point at fairness by design in terms of actionable contract, like smart contracts that can basically testimony and pass on to the further research, that agreement, maybe also thinking about blockchain technology and this kind of thing that could be quite useful. So all in all, before opening the floor to the questions, of course, I think we are witnessing a moment where there needs to be an action at the European or possibly at the global level, focus on research and asking the fundamental questions. Which kind of data are research data? Try to come out with a definition. What could be a legal basis? Consent, legitimate interest. You rightly pointed out, Giovanni, that legitimate interest is not applicable to special categories of personal data. Shouldn't we look at a derogation here? Shouldn't we look at something that if you process personal data in a fair way, maybe legitimate interest can also be applied to special categories of personal data? Just saying something for food for thoughts. And at the end of this process, which is going to take time, how do we formalize it in a way that is not just relevant for Europe, but relevant at the international level? So now I would like very much to open the floor to questions, please.
Could I just a quick interjection? Aurelia and I don't agree on fairness is focused on an individual. Fairness can be focused on a community. Fairness can be focused. That's why you do stakeholder analysis, to begin to understand the interests of all of those parties. The second point I would just like to make is in Canada, there's soon to be a discussion of how you merge the concept of socially beneficial activities with legitimate interest to free up data for a digital society, and I think that's a very relevant conversation for here as well.
Thank you. Let's open the floor. Let's collect 2-3 questions at the same time, just for optimize the time. Please, you go to the microphone. There is already one question there. Yes.
Alessandro Mantelero, Politecnico Torino and Council of Europe. The first is a sort of remark, if you want.
Sorry, can you speak louder, please?
Okay, more than is difficult for me. And the first is a sort of remark because it was mentioned that if there is no consent, there is no chance to know the manner in which data are processed. I think it's wrong because there is a specific provision in the GDPR that say that the consent is a legitimate ground, but in any way you have to provide some specific information about the manner in which data are processed. I think it's important to clarify and avoid this kind of misinterpretation. And the second is a question. You touched the point of the broad consent. Broad consent is in the recital 33 of the GDPR. And in the recital, the reference is specific to research only. But according to your interpretation, what it means, research in this context? Because it's quite broad terms. And moreover, why we cannot apply the same idea of the broad consent to artificial intelligence and machine learning, in which it is very difficult to define ex ante at the beginning the purpose of data processing, and if you want to apply to machine learning this provision, this suggestion more than a provision because it's a recital, how you can apply this, considering then when you use machine learning, in many cases it's unclear when finish the stage of the research and start the stage of the normal running of an algorithm. So this is the question. Thanks a lot.
Thank you. Let's collect another questions too. Yes.
Okay. Thank you. Barbara Egel, the DPO of the European Central Bank. So I have nothing to do with research. There's a disclaimer, I'm not a researcher, but I get a lot of questions regarding possibility of research. So my questions are the following. First, what are your views as regards the use of data derived from social media, published posts of social media users? Second, I'm very surprised that you use consent so much as a basis, as a legal basis. I see a lot of problems with that. Namely, for example, if you use companies to conduct surveys on your behalf, and these companies actually buy the addresses of potential respondents, and then they pay to these respondents for filling out questionnaires, how free is this consent? Second of all, withdrawal of consent. What does that do to your databases? If an individual withdraws consent, you cannot process any further. Thank you.
Okay. Let's stop. Let's take these two questions because they were quite large, particularly the first question, and then we give it time for other questions, okay? Who wants to answer to the first questions addressed by Professor Mantelero?
I will give a quick answer because unfortunately I must leave in 2 minutes. You are right what you say, Alessandro, about consent, but here what we are talking about, it's really a revolution in research that really requires to a large extent to move beyond what we have in our hands, which is the GDPR. And brings me to a sort of counter question, because the reality is that when we are talking now in data-intensive research, by definition, it's normally international. So Michel was stressing the difficulty of matching two data sets within one country because of the legal framework and the organization. But data-intensive research, it's basically, by definition, transnational. So data sets are in different countries, in different continents. So they must go to a global scale. What I was referring to in terms of broad consent was mostly referring to, we have to think ways to enable individuals in making their choices, to express their will, their interest, in ways that can give just blanket, large scope for research, exactly because we don't know where our research can lead us. And it would take ages to answer your question, but there are provisions in the GDPR taking into account clearly we have a right to withdraw consent. But this has, again, huge consequences for the data set unless we technically are able, and you will draw your consent for your data, but if we can unlink you from the data, we can still retain the data and make good use of it. But it will take too much, and I only must apologize because I must leave.
Thank you, Giovanni. Somebody wants to add something?
On the question of consent, there's no question in my mind that consent has to be informed and it needs to be based on a real understanding and knowledge. In the type of research that we're talking about, people can't really, you can't say they have the knowledge because that's just impossible. So the fact is this concept of sensitive data and how can you free up sensitive data in some other way based on a sense of responsibility as it relates to something like that relates to something like legitimate interest. Legitimate interest is not based on a fulcrum, but legitimate interest based on an algorithmic look at the full range of fundamental rights of individuals. And individuals have an interest in something more than autonomy. They have an interest in their children having better health in the future. They have an interest in safer roads. They have an interest in multiple things. And the concept of data protection is about the full range of fundamental rights, not just the simple concept of privacy.
Yeah, and I think I would add that I think for us, maybe when I bring up the idea of consent, I think for us it's more of an eye-opening concept in the sense that it's an opportunity to engage with the stakeholders. And it's an opportunity to have a discussion about what the value of information is, to make sure that they also they benefit from the data processing activity itself. And that could very well be a free service or a financial remuneration. I think there's a lot of opportunity for this that has been relatively unexplored. But until we give people the opportunity to meaningfully engage in both the provision and also the restriction of these data, I don't think that we can achieve that. So I see it as a huge opportunity, and the way that we're framing the project, I think, is how do we make sure all the stakeholders are involved and engaged and can understand what their rights and responsibilities are and can meaningfully participate in that project. So I would see this as more of a democratic engagement strategy more than a data protection problem. They're related, but I think there's a bigger picture here. And if we do it this way, if we think about it in this context, then I think we can also look at other problems that arise from machine agents that process data and look at things about scope and use, and is that understood by the people? Is it transparent to the stakeholders? Is it lawful? And so on. All of these things can be wrapped up in that.
There was maybe also one last question. You mentioned about social media usage and this kind of difference that is not always made outside of Europe between public data and non-public data, and the fact that it's not because data is public that you can just use it. So it's a good reminder of it's not because it's out there that you can actually use it without any issues.
Just a an additional consideration, maybe more from the legal perspective. When we talk about broad consent, it seems a little bit a sort of contradiction in terms, in the sense that I think Martin before clearly mentioned that it's very difficult for a data subject to understand what they are consenting about. It's even difficult when it comes down to cookie, which is fairly out there. It has been out there for some time and still is not really understood. Not to mention when we are talking about extensive research and the possible consequences. And if you make the consent broad, then it means that it captures even more. So it's not specific anymore, but also you put more information on the plate of the data subject that needs to process them. So ideally, it's perfect. In practice, I would have numerous challenges to the validity in the first place of that specific consent. Another point, and I think it's important to make a distinction between purposes and means, because before in the first question you mentioned why can't we use the broad consent to artificial intelligence and machine learning. But I think we really need to understand what is the purpose, and the purpose will be subject to the lawful basis, and the means, like processing those personal data by way of artificial intelligence or machine learning techniques and so on and so forth. But what is interesting is that sometimes the means is defining also the purposes. And blockchain, for example, is one of the elements of that, and especially when you talk about artificial intelligence, also by use of that technology and the fact that it brings about new correlations, then it redefines the purposes. So this is also another very important issue that we need to discuss. Of course, that needs to be discussed at large.
Yes, I want to say something about the social media data.
I think on social media, you answered that orally. I don't know. I mean, on social media in Europe, at least, even though the data are public and out there and voluntary, let's say voluntary given by the data subjects, they are still subject to the GDPR and subject to all the legal obligation, whereas in the United States there is a completely different concept, or a fairly different concept on that. So also on the use of data that we capture from social media, we analyze from social media, we still need to apply Article 6 of the GDPR. And then once again, of course, I don't foresee very much the possibility of consent, but maybe going more towards the legitimate interest and so on and so forth. But there is an additional problem there, because it's also important to understand who does what on social media. And a recent decision of the Court of Justice of the European Union that you all know on Facebook Inside established the joint controllership relationship. And I think we're going to hear more and more about joint controllership and less of processor and controller, which I think is outdated and not really reflecting anymore the state of the art. So it's a huge discussion, but in that discussion, even if they are on social media, data are subject to the GDPR, focus very much on their role and try to establish what is the right allocation and make it contractual agreement on that. That's another point. Privacy is going to become more contractual.
To highlight maybe how this is changing also, in a panel yesterday, Max Schrems was floating the idea that users of Facebook could actually also be data controllers, like somebody who uses a WordPress page. So I think we are really in a time where these concepts, these legal concepts, are fluctuating and being put to the test. And it's time to start thinking about what comes after the GDPR.
And also,
very briefly,
yeah, very briefly, to add on social media data, I fully agree with Aurélie. The fact that it's all open there doesn't mean that it can be used by anybody. And also we have to consider the interest of third parties. The fact that I have posted something on social media may affect my family circle, my friend circle, or any other third party that has any knowledge about this posting. So we can't just say, yeah, it's there, let's use it, and then not consider the risks that are related to to it.
Okay, let's take another question, so another two, if there are someone else, please go home.
So, going back to the fairness, so I'm not a legal scholar, I'm an ethicist and political philosopher. So I ask first a legal question and then an ethics question. The legal question is, in the field of fairness by design, machine learning, not all, but most, and certainly the most efficient ways to apply fairness regularizers to the predictive models produced with machine learning is require the use of the sensitive variables. So basically you need information about things like gender in order at least to train the models. So what instruments does the law give to companies who would like to make these less discriminatory models but need to use this kind of information? And maybe I just ask this because the ring has bell.
We have still 5 minutes, we can go on. Any other questions? Because we collect the last one and then we make a round? No? Then let's answer and then let's make just a close statement for all the panelists, okay? Who wants to take on board these questions?
All right.
I won't take on the legal part because God knows I'm an anthropologist and a philosopher as well. But the question of how you model out all of the questions related to fairness goes to the impacts of inaccurate insights. And this whole question of how you model out fairness to include this question of if I don't have full data sets, by definition, I will have insights that are inaccurate, which in turn will have impacts that I can't even understand, raises up this question to how do I find the way, from a common law perspective, how do I find a way around those boundaries? But the fact is that the whole concept of full range of fundamental rights, assuring that you don't have negative impacts as part of a fairness design, says that you have to figure out a way to get the data necessary to have accurate insights. And then you have to take on the question, what do you do with the insights? But inaccurate insights by their are just per se not going to be fair.
I think it depends also. Maybe we can agree on that one, Marty. It depends on the outcomes also and the consequences of the outcomes.
Mm-hmm.
It's not a black and white answer. It's not it's fair, it's unfair. In the end, it's also a matter of, is it acceptable, yes or not, this unbalance I might have within my data sets.
But the process by which you come to that decision has got to be somewhat transparent. You have to be able to absolutely demonstrate that you've got there based on the interest of others, not just your own interests.
And this is where I think something Michel highlighted as well is we need to understand where the data comes from and things like that, which is one of the challenges of the GDPR as well, is about data traceability, is about transparency and things like that.
Maybe just more on the legal perspective, because you call out that specific answer. I think what you do in the preparation of setting a control that needs to be in place to assess fairness, so you're doing a preparatory work, and that preparatory work entails the processing of personal data, then once again we need to try to look at the legal basis that we have at disposal in order to see whether one of them can fit. For sure, we're not going to look into consent because we are in a preliminary phase where probably you don't even have a direct contact with the individual, or you may not have a direct contact with the individual, or it is not feasible to do that. So I think we should once again look into the possibility of arguing a legitimate interest or going for something that is broader, like a public interest. Because eventually, if we are thinking about an ecosystem for research, where it is clear that the research that you are doing needs to have a fair and ethical impact on the society, it seems that by definition, you are dealing with the society and you are not dealing with a single individual. So even when we are rethinking about the possible legal basis and the environment in order to enable that specific data processing related to research data, this should also be taken into consideration. and maybe create this concept of, extend the concept of public interest if those specific data processing are made in order to create a further control on fairness, which is for the benefit of the society.
Good. Thank you very much. Time is elapsed. Thank you very much for all the speak. Thank you.